G'day everybody, and welcome to the week 6 lecture for Laws 12063 Advanced Statutory Interpretation and Drafting. I'm Anthony Marinac. This week we're going to finish up with the theme for the first half of this course, which is really about the elements of legal writing. 2 weeks ago we looked at the rules of grammar. Last week we looked specifically at legal vocabulary. And this week we're going to look at the principles and practice of plain English drafting. Plain English drafting as an idea is a little bit broader than simply grammar or vocabulary. Plain English is partly a theory of how we should write. It's partly a philosophy in terms of how the law and the legal profession should communicate with lay people and people from other professions. It's partly a philosophy about how accessible the law should be to people without legal training. And it's partly a practical exercise in writing or drafting statute or contracts or wills or any other sorts of documents in ways that are accessible to all readers. The fundamental notion behind plain English is that legal writing is too complex and that it need not be. The idea behind plain English is that we can write legally sound documents which have exactly the same legal effect as really complicated documents, but without having them written in an incomprehensible way. 2 things to know about the plain English movement. First thing is that while I refer to the plain English movement as a movement, it's not really. It's not as though there is a headquarters or an organisation or a leader. It's more of a school of thought. There are people who are particularly committed to the notion of plain English and people who are not committed to it at all. The second thing to note is that whilst the plain English movement these days is starting to become the majority and perhaps even starting to find comprehensive acceptance, for a long time the plain English movement met with heavy opposition from within the legal profession. People were used to doing it the old way and they preferred to do it the old way, and one of the biggest concerns by people who didn't want to write in plain English was that some of the specifics, some of the detail that is necessary in legal documents would be done away with in the rush to write plainly and simply. Legal experience had taught many of these practitioners that when you write in a simple way rather than in a complex way, it may be easier to read, but it may lead to a situation where you have more ambiguity and therefore the need for more legal disputes. So their concern was that if everyone starts writing in too much of a plain English way, we may actually end up in a situation where we have more easily understandable legal documents, but many more legal disputes, and in particular many more legal disputes which wind up in court and wind up costing our clients a whole lot of money. There is still that school of thought out there, the school of thought that says there's no need for plain English, that legal documents are complicated because they're supposed to be complicated. And the reason why people hire lawyers is because legal documents are difficult to read and we as lawyers have the skill of reading them. For our purpose, while we acknowledge that school of thought, we're not going to adhere to it. For this lecture and for the rest of this course, I'm going to take the view that there is much to be learned from plain English, and that when plain English is applied sensibly and according to the 5 principles of plain English that we're going to be discussing in this week's lecture, there is absolutely no reason why lawyers shouldn't write and communicate in plain English without losing any of the legal rigidity and legal strength which comes from a well-written legal document. Now, there's been a lot written about plain English, and I could probably talk all day about it, But I think the best way to begin and to work through the idea of what plain English really is to break it down to what we call the 5 C's, or the 5 principles. If you have an understanding of these 5 principles, you'll have a pretty solid understanding of what plain English is all about. After that, I would say it's probably time to stop reading about it and start practicing it. And what you'll find is that the more you practice plain English, the better you'll get at it. So what are those 5 principles? The 5 principles are coherence, comprehensiveness, consistency, clarity, and care. Let's go through them one by one. The first one we want to talk about is coherence. Obviously, there's no point writing a legal document which is incoherent. What do we mean by coherence? What is a coherent or an incoherent document? A coherent document is one which you can read from beginning to end and it makes sense. It doesn't jump around from thought to thought, from place to place. It has well-written sentences that are not in sentence fragments. It's not just one great big block of small print text across the page. It'll be broken into sensible paragraphs. It will have subheadings. The information will be presented in manageable proportions, which are then linked to one another logically, which allows the reader to be guided through a series of thoughts by the author to reach the conclusion that the author seeks to arrive at. Coherence is actually a lot easier to understand by looking at incoherence. Now, I've been marking university assignments for a few years now, and let me tell you, I've seen some incoherent attempts at writing with no internal logic, jumping about from thought to thought and from sentence to sentence in a way that's impossibly difficult to follow. In the notes, I've written out a paragraph which I believe is basically incoherent. It reads as follows: the positional offer outlined is accepted provided on the conditions herein contained relating to remuneration of $250,000 and my right of reviewing any public representation relating to my acceptance of this conditional offer and the provision of the remunerative bonus as previously indicated, along with provision of documentary recording in minutes form of the three most recently previous board meetings, same to commence 1st of March 2013, along with such additional personal staff as a requisite to my needs and in relation to whom advice is sought regarding recruitment, employment and payment. Now you'll see that, gosh, even I couldn't read that paragraph through without stopping a couple of times to work out what the heck it was actually going on about. There's a lot of information in there. Each point of information on its own makes sense, but it's badly expressed. There's no internal logic. The whole thing is incoherent. It reads and is written by someone who seems almost like they're drunk. I promise you I was sober when I wrote it. What can we do with something like that? We can take that piece of writing and pull it apart into its separate thoughts. And then we can list those separate thoughts in a logical order, in much shorter, simpler sentences, and lead the reader from beginning to end. So that's the first principle of plain English, coherence. We need to have English writing, legal writing, which is coherent rather than incoherent. What are some signs of incoherence? Well, the first and the biggest and best one is sentence structure that's unnecessarily complicated. If you've got too many phrases or clauses in a sentence, or if you've got conjunctions that don't really need to be there because you can safely separate the sentence with the conjunction into two separate sentences, then you ought to do so. There's absolutely no reason for having overlong sentences in legal writing. It's almost always possible to break the sentence up into smaller pieces. The second thing you can do is signpost. Make sure you signpost right the way through the legal document so that it is clear what the purpose of each section is to do. The third thing you can do is make use of paragraphs. Paragraphs indicate to the reader, here is a bite-sized chunk of information. The reader will read that piece of information. They will then process that piece of information before moving on to the next one. So if you've already worked out what are the bite-sized pieces of information that you want them taking each in a chunk, then you'll be controlling the reading process, and as the author, that's what you want to do. Let's have a look at the second principle. The second principle is comprehensiveness. Now this is probably the most important principle of all, and this is the one that makes critics of plain English get worried. Because what critics of plain English are worried about is that in order to simplify documents, people will simply begin leaving stuff out. Plain English does not require you to leave out important information which is required for the document. If the document is not sound in law, if it does not tick the boxes required for a document of that type, then it is not a good piece of legal writing, because it will not accomplish whatever it is that your client is trying to accomplish. In fact, it's even worse than that, because your client may walk out the door feeling like they're covered, feeling like they have secured their interests because they have what they consider to be a well-written legal document, and so they won't take any further steps for their own protection. It's a worse situation than not having a document at all. So don't be tempted to make a document more readable by simply dropping the hard stuff. Now what this means is that sometimes documents are going to be more complicated than you would perhaps like. Sometimes you're going to look at a sentence or a paragraph and think, gee, this is complicated, I'm moving away from plain English, and I really wish I could drop this sentence or this paragraph. If you're writing good plain English, you'll be interrogating each sentence and each paragraph to say, do I really need this? And once you say, yes, I really need this, then you're asking, is it expressed in the simplest adequate way? Now, if you ask those questions of a complicated paragraph, and the answer is, yes, I need this paragraph, and yes, it is expressed in the simplest reasonable way, even though what that amounts to is still a very complicated expression, then guess what? It's still good plain English. Let's underline that. There is absolutely no excuse in accordance with plain English to end up writing something which is written in plain language but which fails to have the correct legal effect. Better to write something complicated and adequate than uncomplicated and inadequate. The third principle of plain English is consistency. Now, a lot of people don't necessarily get why consistency is so important. Consistency is about having a document which is easy to read and easy to follow, because the document speaks with only one voice. Have you ever seen how people from generations much younger than my own, people who were teenagers in the last 10 years, which will include some of you no doubt, often used to write letters or status updates on Facebook or whatever it might be, where they would intermix capital letters and lowercase letters all over the place to make a crazy hodgepodge of letters, so that the words would be written out using the right letters, but they'd be using a crazy mix of capitals and lowercase, and sometimes a crazy mix of different fonts. Have you ever noticed how much harder that made it to read? Consistency makes things easy to read, and there's a range of consistencies which we can have in order to make sure that our writing is as effective as possible. I've listed the 8 most important there on the slide. The first one is consistency of tense. This one's really important. If you have inconsistent tense, so that some parts of the sentence or some parts of the document seem to occur in the past and some parts seem to occur in the present and some seem to occur in the future, then the person reading the legal document may really struggle to understand what the nature of the obligations imposed by that legal document are. Are we reflecting on things that have been done in the past? Are we talking about things that must happen in the present? Are we talking about things that must happen in the future? You must be carefully consistent in relation to the tense of your writing. If you are making a time jump, for instance, if you are going from a section where you have been discussing what's happened in the past and moving into a section where you're now going to discuss what must happen in the future, that needs to be effectively signposted. And then you need to be consistent within each section. The second form of consistency I want to talk about is consistency of voice. What we mean by consistency of voice is that if you're going to write mainly in the active voice, you should do so. If you're going to write mainly in the passive voice, you should do so. I think you'd be a bit silly to write a document that's mainly in the passive voice. But the only thing worse than writing a document that's mainly in the passive voice would be writing a document that randomly slips from one to the other and back again. If you're writing in the active voice, there's no problem with occasionally reverting to passive voice to make a particularly emphatic point. But by and large, your writing should be consistent in its voice to make it as easy as possible to read. The next thing I want to talk about is consistency of tone and level. Consistency of tone and level is really important. It's no good starting out a letter in a really formal sense and then halfway through dropping into an informal voice. By the same token, it's kind of pointless starting a letter out with an informal voice and then all of a sudden ramping it up to a great degree of formality. It gives a very mixed message to your reader. Are you approaching your reader on a friendly basis, or are you approaching your reader on a basis that's strictly business? Are you being aggressive? Are you being matey? It's really important before you start writing to pick out the tone and level that you're going to adopt in the communication and then stick to it right the way through the communication. Next, consistency of format. Now, consistency of format is not really a problem, but a consistent format makes things much easier to read. Readers often find it very jarring if you suddenly have unexplained changes in margins, unexplained changes in font or font size. Or if you're using headings and subheadings in signposts. If you've suddenly changed the size or the font of a heading, are you trying to say that this is a more or a less important heading than the previous one? It can throw the reader off and overall make the document more difficult to read. The next one's really important, consistency in jargon. If you're going to use jargon terms, you need to be really careful to make sure that you're not also using the same word in a non-jargon way. Similarly, if you have a concept, let's say consideration for a contract, there's no point using the term consideration on some occasions and using the term payment on other occasions. You need to be consistent in terms of indicating which words you're using for which concepts. Consistency in language. Now this is pretty similar to tone and level in a way, but consistency of language is about making sure that once you have chosen a position, you're using language which is consistent with that position. The example that I've given in the notes highlights this really nicely. It says, "Dear Mr. Smith, the deadline for your response to our proposal of 17 April has now expired. We therefore withdraw our offer and intend to press this matter to the fullest extent before the courts. Further, we intend to rely on your rejection of our offer on the question of costs. Lots of love, Senior Associate." You can see how, under those circumstances, lots of love at the end of the letter is completely inappropriate. The language is just wrong. By the same token, if you're really angry at somebody, you shouldn't be using profane language in the context of what is otherwise consistently a professional document. Finally, I want to spare a moment to talk about consistent authorship. You see, every author has their own slight voice. Every author writes things slightly differently in a way that is theirs specifically. Now, most of the time, you'd be pretty hard pressed to tell a person's writing just by their voice. But sometimes it can be very jarring if you have a letter where you get the sense that the first half of the letter was written by one person and the second half of the letter was written by somebody completely different, who had their own style. Consistency of authorship therefore makes a document easier rather than harder to read. So far we've talked about coherence. We've said documents need to be coherent. We've talked about comprehensiveness. We've said that documents need to do everything within the law that is required of a document of that type. We've talked about consistency. We've said that a document should be internally consistent so that it's all cut from the same cloth. Now let's talk about clarity. Clarity in many ways is the heart of plain English writing. Plain English writing should seek to be clear. You should seek to convey meaning precisely and without ambiguity. The more clearly that you can express things in written or spoken English, the less likelihood there is of them being misunderstood or ambiguous, and therefore the less likelihood there is that you're going to escalate or initiate a legal dispute. Clarity is the soul of plain English writing. What this means is you should write using crystal clear language, and you should write as long as is necessary, but no longer. There should be no padding in anything that you write. You should use whatever words and thoughts are necessary in order to make your meaning clear, and then you should stop. Now that sounds really easy. In practice it's a lot harder than I'm making it sound, and the only way you can do it well is by practicing, and practicing. Finally today, the final principle of plain English is the principle of care. Now for some of you this is going to sound an awful lot like teaching you to suck eggs. Having said that, you'd be surprised at how many student assignments I see which are clearly not the result of care. You'd be surprised how many student assignments I see, and indeed how many pieces of legal correspondence from practicing lawyers that I see, which have clearly been dashed off and sent without any proofreading and without any reflection. Even if you're a good writer, even if you're a great writer, plain English writing is unlikely to come automatically. You'll be surprised how often, if you proofread a document effectively, you will suddenly realise that something which seemed perfectly clear in your head when you wrote it doesn't actually read that clearly at all when somebody else is reading it, or when you're reading it back to yourself to proofread. Being able to read Being able to write and being able to proofread are entirely different skills. Proofreading is almost a profession in itself, and some of the best proofreaders are paid a lot of money. The problem is that when we're reading, and especially when we're reading something that we wrote ourselves, our brains often see what they want to see. Proofreading is all about tricking yourself into seeing what's actually there rather than seeing what you wish was there or what you think should be there. You have to train yourself to do it. Here's a few ideas to help you along the way. The first one is to proofread when you are fresh and alert. One of the biggest problems is that people will spend a lot of time and effort writing a paper, and then before they turn the computer off, they'll try to proofread it. It's not going to work, guys. What you have to do is write the paper and then proofread it when you're alert and fresh, not when you're exhausted from having just spent the process, having just undertaken the process of writing the document. Second thing I'd suggest is printing the document out. Now, I don't think anyone really knows why looking at a document on paper is different to looking at a document on the screen, but somehow it is. Brains are weird, and somehow our brain lines up words differently when they're printed out on a sheet of paper than it does when they're printed on the screen. So you may find that something which looked a-okay when you saw it on the screen reads slightly differently and needs to be corrected if you print it out on paper. Third thing is break it down. What I suggest you do if you're proofreading is read sentences or paragraphs one at a time, covering up everything else. Otherwise, what will happen is that you'll read the whole document as a document, rather than reading each sentence or looking at each sentence very clearly. Finally, there's a few things you can do to remove the context. You see, what happens is that all of our brains get used to reading, and they get used to anticipating what the end of a sentence is likely to be while we're still reading the first part of the sentence. And quite often, if there's a spelling mistake or something like that, we won't even notice it because our brains have already rearranged those letters in order to determine the meaning. When we're reading, our brains are not usually looking for mistakes. Our brains are looking to interpret meaning. And our brains are perfectly capable of not seeing a spelling error because they're too busy searching for the meaning of what word those letters were trying to form. In order to proofread effectively, what we have to do is teach our brains to stop looking for meaning while we're proofreading. A few ways that I would suggest is first, read the document from bottom to top. That way, the meaning is probably not going to be there, and so your brain will be freed up from the need to look for it. Similarly, read the document backwards. So, from the last word to the first word. That's probably only going to be useful for spelling. I think reading the document from bottom to the top, one sentence at a time, makes a lot more sense if you're thinking about grammar or thinking about the arrangement of your thoughts and how you could edit the document to be just as effective, only shorter. Finally, you could read the document upside down. If you turn a document upside down, you'll find, strangely enough, that you'll be perfectly able to read it. It just takes a little bit more brain effort. Because the brain's putting in that additional effort to recognize what the words are and then to structure them into sentences that run right to left instead of left to right, you'll be surprised how often things come out that you didn't see the first time round. Finally, and perhaps most importantly, I would suggest that you take time to stick your writing in the deep freeze. When I've written something, I leave it for at least 24 hours and sometimes for up to a week. And this allows me to come back to the writing with fresh eyes and see mistakes that I simply wouldn't have been able to see if I had been proofreading it immediately after or even the next morning after finishing it. So there we have the principles of plain English. Let's go through them again very quickly. The first one is coherence. Your writing needs to be coherent. If it's not coherent, it's going to be impossibly difficult for your reader to decipher what your meaning actually is. Second, your writing must be comprehensive. If your writing is not sufficiently comprehensive to accomplish its objectives in law, then you may as well not be writing at all. Third, writing should be consistent. Inconsistent writing is hard to read, it's hard to get a sense of, and it confuses readers. Fourth, writing should be clear. This is the soul of plain English. Your writing should be crystal clear and as long as necessary, but no longer. Finally, your writing should be the result of care. It's not going to come automatically, and you need to develop the skills of proofreading in order to be a good writer. Now this week there's only one exercise, and it should only take you about half an hour or so, but it's a good exercise to do. What I've taken is a block of absolute gibberish legalese, but it's the real deal. It's actually used by banks in the United States as part of the agreement that's made by someone when that person, well, by a merchant, when the merchant gets an ATM machine to allow them to accept credit card transactions. It is gibberish, and what I'm going to ask you to do is identify why and how it's gibberish, and then rewrite some of it in a plain English style to prove to yourself that it can be done. Once you've got these skills, they'll be useful to you in all sorts of contexts, not just in a legal writing context. I hope you enjoy the exercise. I hope this lecture's been useful to you, and I look forward to talking to you again next week.